This is part 15. Right in the beginning, we shall continue our discussion as far as liabilities of the parties with respect to a negotiable instrument is concerned. To understand this,
The chapter with which we started our discussion is right from section 26 up to section 45A of the Negotiable Instrument Act. Right in the beginning, right from section 26 up to section 29 are the sections where we dealt with who are competent parties as far as Negotiable Instrument Act is concerned, because this is a contract and must be entered into by the parties who are competent to contract, otherwise not enforceable by law. With this now, when we started discussing right from section 30 onwards liabilities of various parties. Now this is a time for me to draw your attention to last section as far as liability of the drawer is concerned, namely section 45A, and it deals with what? The heading is holders right to duplicate of lost bill, and what it says, where a bill of exchange has been lost. So the bill of exchange has been lost before it is overdue. Before it is overdue, the person who was the holder of it may apply to the drawer. So if the bill of exchange has been lost before it is overdue, the person who was the holder of it may apply to the drawer. So when he has lost, what he will do, such a holder will apply to the drawer to give him another bill of the same tenor, giving security. At the same time, what the holder will do, giving him security to the drawer if required, to indemnify him against all persons whatever, in case the bill is alleged to have been lost, shall be found again. So this is this also has got reference to contract of indemnity, for which you have to refer to two sections, namely section 124 and section 125 of the Indian Contract Act. So now this is he will to indemnify. So what he says, when the bill of exchange has been lost before it is overdue, the person who was the holder of it may apply to the drawer. He will apply to the drawer to give him another bill of the same tenor, giving security. So he will give security to the drawer if required to indemnify him. So he will indemnify the drawer against all persons whatever, in case the bill alleged to have been lost shall be found again. And why we started discussing with this, and the further part of the sections talks about liability of the drawer, and it says, if the drawer on request as aforesaid refuses to give such duplicate bill. So there is refusal on the part of the drawer to give such duplicate bill, he may be compelled to do so. So it's his duty, and if he fails in his duty, there starts his liability as far as section 45A of the Negotiable Instrument Act is concerned, which deals with liability of the drawer. With this now, we come back and we start discussing section 41, which deals with liability of the acceptor. And what it says, section 41, acceptor bound although endorsement forge. Now forgery is nullity, conveys no title, and hence now if you read section 41, it says an acceptor of a bill of exchange already endorsed is not relieved from liability. So acceptor of a bill of exchange
already engrossed is not relieved from liability by reason that such engrossment is forged. When, if he knew or had reason to believe the endorsement to be forged when he accepted the bill. So when he accepted so who is an acceptor? Drawee, when he has accepted the bill of exchange, is what is known as an acceptor. So now when he has accepted the bill of exchange, he knew or had reason to believe the endorsement to be forged. In that case, he is liable. An acceptor of a bill of exchange already endorsed is not relieved from liability, so he is liable. So this section 41, deals with liability of the acceptor as far as forged endorsement is concerned. When, how, why is dealt as far as section 41 of this chapter is concerned. Section 42, acceptance of bill drawn in fictitious name. And what it says, an acceptor of a bill of exchange drawn in fictitious name and payable to the drawer's order is not, by reason that such his name is fictitious, relieved from liability to any holder in due course, claiming under an endorsement by same hand as the drawer's signature and purporting to be made by the drawer. So that is again liability of an acceptor as far as section 42 is concerned. Section 43, in a case where negotiable instrument made etc. without consideration. And it says a negotiable instrument made, drawn, accepted, endorsed or transferred without consideration, or for a consideration which fails, creates no obligation of payment between the parties to the transaction. But if any such party has transferred the instrument with or without endorsement to a holder for consideration, this further part is very important, which says, but if any such party has transferred the instrument with or without endorsement to a holder for consideration, such holder and every subsequent holder deriving title from him may recover the amount due on such instrument from the transferor for consideration or any prior party thereto. So that is liability of the parties as far as in case when the negotiable instrument is without consideration, dealt by section 43. But then along with this is the time for us to take into consideration the exception 1. And what is exception 1? No party for whose accommodation. So this is what is known as accommodation bill. When A wanted to raise the amount of 10,000 rupees, he draws a bill without consideration on Mr. B, who accepts it in order. He lends his name only. That's all, nothing more than that. From the point of view of accommodation, this is what is known as accommodation bill. So exception says no party for whose accommodation a negotiable instrument has been made, drawn, accepted or endorsed can, if he has paid the amount thereof, recover thereon such amount from any person who became a party to such instrument for his accommodation. That is first. Second exception says no party to the instrument who has induced any other party to make, draw, accept, endorse or transfer the same to him for a consideration which he has failed to pay or perform in full, shall recover therein an amount exceeding the value of the consideration, if any, which he has actually paid or performed. And then with this now, as we proceed further, section 44 deals with partial absence or failure of money consideration. And it says, when the consideration for which a person signed a promissory note, bill of exchange or check consisted of money and was originally absent in part or has subsequently failed in part, the sum which a holder standing in immediate relation with such signer is entitled to receive from him is proportionately reduced. And the explanation says, the drawer of a bill of exchange stands in immediate relation with the acceptor. The maker of a promissory note, bill of exchange or check stands in immediate relation with the payee, and the endorser with his endorsee. Other signers may by agreement stand in immediate relation with a holder. So that is the explanation as far as section 44 is concerned. And the illustration to the section makes it very clear. It says, A draws a bill on B for rupees 500 payable to the order of A. B accepts the bill but subsequently dishonors it by non-payment. A sues B on the bill. B proves that it was accepted for value as to rupees 400 and as an accommodation to the plaintiff as to the residue. A can only recover 4,000 rupees, though the amount that appears is 500 rupees. Lastly, section 45 deals with partial failure of consideration not consisting of money, and it says, where a part of the consideration for which a person signed a promissory note, bill of exchange or check, though not consisting of money, is ascertainable in money without collateral inquiry, and there has been a failure of that party, the sum which a holder standing in immediate relation with such signer is entitled to receive from him proportionally reduced. So that is as far as section 45 of the Negotiable Instrument Act is concerned. With this now, the next chapter, chapter 4, deals with negotiation. And if you remember, we have dealt with this chapter right from section 46 up to section 60 of the Negotiable Instrument Act. Chapter 5 starts right from section 61 up to section 77 of the Negotiable Instrument Act. And this chapter deals with what? This chapter deals with presentment. Now, depending upon whether it is a promissory note, whether it is a check, or whether it is a bill of exchange, there should be presentment. When you talk about presentment, there can be presentment for acceptance and presentment for payment. Provisions regarding presentment for acceptance come into operation only in a case of bill of exchange. The provision regarding presentment for acceptance is not at all applicable because the question doesn't arise in case of a promissory note and in case of a check. In case of promissory note and in case of check, as in case of bill of exchange, it is the provisions regarding presentment for payment are applicable. And hence now this chapter, when it is required to be presented, where it is required to be presented, whether presentment is made compulsory by the provisions of the Negotiable Instrument Act or presentment is unnecessary. Without presenting, it is possible for the person to get the amount with respect to the negotiable instrument, namely the amount for which the negotiable instrument is drawn is dealt as far as this chapter is concerned. Now, to begin with, section 61 deals with, first of all, presentment for acceptance, and it says a bill of exchange. Now, presentment for acceptance is the provision, I again repeat, applicable as far as bill of exchange is concerned. In case of bill of exchange, drawer has given direction to drawee to carry out payment with respect to the bill of exchange, and hence now drawee will carry out the payment, or he will pay the amount for which the bill of exchange is drawn, subject to one condition, that is, his liabilities start only when he has accepted the bill of exchange, otherwise not. Hence now, once you start reading section 61 now, presentment for acceptance, it starts with the wording a bill of exchange. So this section is applicable only as far as bill of exchange is concerned, because this is the provision that is applicable. Presentment for acceptance is the provision that is applicable as far as the bill of exchange is concerned. It says a bill of exchange payable after sight must. So a bill of exchange which is payable after sight, and this has got reference to what? When it becomes mature. For the purpose of understanding this, we dealt, when we were dealing with holder in due course, we tried to understand that a person can become a holder in due course provided he has received the negotiable instrument before maturity. And for the purpose of understanding maturity, we dealt right from section 21 up to section 25. So now the bill of exchange is payable after sight. It is payable after sight. In that case, it says a bill of exchange payable after sight must be presented to the drawee thereof for acceptance. It must be presented, the bill of exchange which is payable after sight must be payable. It must be presented to the drawee thereof for acceptance if no time or place is specified therein for presentment. So this is must only in a case where no time or place is specified therein for presentment. No time is mentioned, no place is mentioned. So in such a case, a bill of exchange which is payable after sight must be presented to the drawee thereof for acceptance. If he can, after reasonable search, be found by the person entitled to demand acceptance. So the person is entitled, one who is entitled to demand acceptance, if he can find out the person after reasonable search be found within a reasonable time, after it is drawn, and in business hours, on a business day. So now he can, within a reasonable time. Now this has got reference to what? When we deal with this particular term, we have already dealt with the chapter section 105, section 106 and 107 deals with reasonable time. So now, in default of such presentment, so when this presentment is made compulsory, there must be presentment for acceptance before presenting it for the purpose of payment. And the further part of this section says, in default of such presentment, no party thereto is liable thereon to the person making such default. So if a person makes default in presenting it for the purpose of acceptance before presenting it for the purpose of payment, then naturally what it says, in default of such presentment, no party thereto is liable thereon to the person making such default. So who I mean, he is not liable to the person making such default. That is I mean. Further part. If the drawee now, after reasonable search, if the drawee cannot after reasonable search be found, the bill is dishonored. So if it is not possible for the person who wants to present it for the purpose of acceptance to find out drawee, after reasonable search, he has carried out reasonable search, but it is not possible for him to find out the drawee, then it says if the drawee cannot after reasonable search be found, the bill is dishonored. So this bill is dishonored for what? Bill of exchange is dishonored for non-acceptance. Now this is dishonor of a bill of exchange for non-acceptance when it is presented for the purpose of payment, and if the payment is not carried out, person doesn't pay the amount, the acceptor doesn't pay the amount, then we say the bill of exchange is dishonored for non-payment. So dishonor of a bill of exchange can take place in two ways: when it is dishonored for non-acceptance and also dishonored for non-payment. Now further part says, if the bill is directed to the drawee at a particular place, so bill is directed to the drawee at a particular place, it must be presented at that place. So it must be presented at that place. And if at due date for presentment he cannot, after reasonable search be found, there the bill is dishonored. So when bill is dishonored, again I mean this clause says, if the bill is directed to the drawee at a particular place, the place is mentioned, it must be presented at that place, and if at the due date for presentment he cannot after reasonable search be found, the bill is dishonored. And the last part of the section says, where authorized by agreement or usage, a presentment through the post office by means of a registered letter is sufficient. So it also says that generally everybody may be under impression that it is as per what it is required to be presented in person. But then further part says, when authorized, where it is authorized by agreement or usage, that is, there is a practice as far as that commercial world is concerned, where presentment through the post office by means of a registered letter is sufficient. So as per the usage, they present it as per the registered letter. Then in that case, or if there is an agreement to that effect, so it says where authorized by agreement, when it has been authorized by agreement or usage, a presentment through the post office by means of a registered letter is sufficient. So this is regarding presentment for acceptance. Now section 62 deals with presentment of promissory note for sight, and what it says, a promissory note payable at a certain period after sight. So what is the nature, how the promissory note is drawn? It is made payable at a certain period after sight, must be presented to the maker thereof for sight. If he can after reasonable search be found by a person entitled to demand payment within a reasonable time after it is made and in business hours on a business day. So presentment of promissory note for sight, and then the further part it says, in default of such presentment, it is required to be presented, and in default of such presentment, no party thereto is liable thereon to the person making such default. So that is as far as section 62 is concerned. Section 63, drawee's time for deliberation. Now this has got reference to what? This has got reference when we talk about drawee. This drawee is time for deliberation. This has got reference to the bill of exchange. And what it says? The holder must, section 63, the holder must, if so required by the drawee of a bill of exchange presented to him for acceptance, allow the drawee. The bill of exchange is presented to the drawee for acceptance by the holder. So, what is the practice that is followed? It says, such holder must allow the drawee 48 hours. So, he must allow drawee 48 hours exclusive of public holiday to consider whether he will accept it or not. So, the time that is given to the drawee to think over whether he is going to accept it or not is 48 hours exclusive of public holidays. And public holidays has got reference, or you can understand it provided you refresh your memory by reading section 25 with which you are dealt. So this is the time that is given. So whether to accept it or not, it is must. I mean, this is a drawee's time for deliberation. So it says the holder must, if so required by the drawee of a bill of exchange presented to him for acceptance, allow the drawee 48 hours exclusive of public holidays to consider whether he will accept it or not. And if there is no communication that is made by the drawee as far as this time factor is concerned, then it is must for the holder to take it for granted that the bill of exchange is dishonored for non-acceptance and take further steps with which we shall be dealing. So once it has been dishonored, maybe for either non-acceptance or non-payment, what are the next steps? Provision to be followed as far as the notice of dishonor and rest of the part is concerned. Notice of dishonor is required to be given, and rest of with which we shall be dealing right from section 91 onwards of the same, namely the Negotiable Instrument Act. With this now, section 64, presentment for payment. It says promissory notes, bills of exchange and checks must be presented for payment to the maker. So to the maker as far as the promissory note is concerned, acceptor or drawee thereof respectively by or on behalf of the holder as hereinafter provided. In default of such presentment, the other parties thereto are not liable thereon to such holder. So presentment for payment is must in case of a promissory note, bill of exchange and check to the party who is supposed to carry out payment. And further part of the section says, where authorized by agreement or usage, a presentment through the post office by means of registered letter is sufficient. Now there is only one exception which is laid down. It says where a promissory note is payable on demand. How it has been drawn? A promissory note is payable on demand and is not payable at a specified place. So the promissory note which is payable on demand, which is not payable at a specified place, no presentment is necessary in order to charge the maker thereof. Maker under any circumstances is liable when the promissory note is payable on demand, which is not made payable at a specified place, is made very clear as far as the exception to section 64 is concerned. Subclause 2 of this section deals with check, truncated check, and we shall come to discuss the provision as soon as we finish with the remaining part as far as section 6 of the Negotiable Instrument Act is concerned, with which you are not dealt so far, which deals with further part as far as the definition of the check is concerned. With this, which are the, when you talk about presentment, the hours of presentment, and that is dealt by section 65. It says hours for presentment. It says presentment for payment must be made during the usual hours of business, and if at a banker's, within banking hours. So that is as far as section 65 is concerned. Section 66, presentment for payment of instrument payable after date or sight. And it says a promissory note or bill of exchange made payable at a specified period after date or after thereof must be presented for payment at maturity. So when if a promissory note or bill of exchange is made payable at a specified period after date or sight thereof, it must be presented for payment at maturity. Section 67, presentment for payment of a promissory note payable by installments. If the promissory note is drawn which is payable by installment, it says a promissory note payable by installment must be presented for payment on the third day after the date fixed for payment of each installment, and non-payment on such presentment has the same effects as non-payment of the note at maturity. So that is as far as section 67 is concerned. Section 68, presentment for payment of instrument payable at a specified place and not elsewhere. And it says a promissory note, bill of exchange or check made, drawn or accepted payable at a specified place and not elsewhere must, in order to charge any party thereto, be presented for payment at that place. Section 69, instrument payable at a specified place. It says a promissory note, bill of exchange made, drawn or accepted payable at a specified place must, in order to charge the maker or drawer thereof, be presented for payment at the place. Now section 70 deals with the cases where presentment where no exclusive place specified where it is to be presented. It says a promissory note or bill of exchange not made payable as mentioned in section 68 or 69 must be presented for payment at the place of business, if any, or at the usual residence of the maker, drawee, or acceptor thereof, as the case may be. Now, in a case where presentment, when maker etc. has no place of business or residence, section 71 says, if the maker, drawee, or acceptor of a negotiable instrument has no known place of business or fixed residence and has no place is specified in the instrument for presentment for acceptance or payment, such presentment may be made to him in person wherever he can be found. Now, presentment of check to charge drawer. It says, subject to the provisions of section 84, when we shall be dealing with the discharge of parties, we will take into consideration section 84, but it says, subject to the provisions of section 84, a check must, we will repeat this again, a check must, in order to charge the drawer, be presented at the bank upon which it is drawn before the relation between the drawer and his banker has been altered to the prejudice of the drawer. Section 73 also deals with presentment of check to charge any other person. It says a check must, in order to charge any person except the drawer, be presented within reasonable time after delivery thereof by such person. Now, in case when the instrument is payable on demand, section 74 deals with it, and it says, subject to the provisions of section 31, a negotiable instrument payable on demand must be presented for payment within reasonable time after it is received by the holder. Section 75 deals with where presentment by or by to agent, representative or deceased or assignee of insolvent, and it says presentment for acceptance or payment may be made to the duly authorized agent of the drawee, maker or acceptor as the case may be, or where the drawee, maker or acceptor has died, to his legal representative, or where he has been declared an insolvent, to his assignee. And section 75 sub capital A says excuse for delay in presentment for acceptance or payment. It says delay in presentment for acceptance or payment is excused if the delay is caused by circumstances beyond the control of the holder and not imputable to his default, misconduct or negligence. When the cause of delay ceases to operate, presentment must be made within a reasonable time. With this now, when this presentment is unnecessary, and then the liability of the banker for negligently dealing with bill presented for payment is the part with which we will continue our discussion in the next part as far as our series of lectures is concerned.